following program on Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we take a look at the diverse uses of land and the laws that govern it. Legal matters in relevance to servitudes and the allocation of land for a variety of uses is an important aspect to be clear when considering the expansion of enterprise and the daily functioning of society. Investors and even novel business ventures rely a lot on a smooth functioning legal system to use land effectively and efficiently. In this backdrop, where are the key loopholes in understanding the laws related to property? How can it be made more efficient to create a more conducive business environment? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now today's topic is a sort of subsection that we have initially discussed, and we got to discuss the land law topic with President's Counsel, the late Mahieash. And today we'll be discussing something that is very much pertinent, something that has been discussed within our legal field for quite some time. So it's something that is affecting almost everyone, you and me, when it comes to land-related matters. And for that, we have an expert in the field and someone who I have a great honor of interviewing multiple times, President's Counsel Seevali, Amithirigala. Thank you once again, sir, for joining me.
Thank you for having me. It's a pleasure coming back.
Thank you, sir. I think revisiting our previous programs, it has always been a very fruitful discussion, and you always seem to give a lot of clarity to a lot of things that we discuss, something that I have had the good fortune of undergoing as a student of yours. As usual, we'll give a breakdown to our viewers as to where we are going to take this discussion. We'll be breaking it down into 3 segments so that it's easier for our viewers to follow with everything that we'll be discussing. Firstly, we'll give a breakdown of what exactly a servitude is. Now, that will be our primary point of discussion with this program, what the law of servitudes are, what the analysis behind it is, and what is the common law that dictates most of the practices that comes into this specific field. Next, we'll be discussing a bit about the creation of a servitude. And finally, we'll be discussing a bit about the reforms that are relevant to this area of law.
Hello, I'm Sarah Fernando, and I'm an IT undergraduate. My question is about law of servitudes. How is a servitude identified in Sri Lanka's property law?
All right, let's get into the discussion directly. President's Counsel Seevali Amithirigala. Thank you, sir, for joining me once again. So to give a breakdown, I think I need to give you some time on approaching the topic, because law students might be aware of this as they study this on a daily basis, but what a servitude is, because the term itself has different meanings when it comes to the general use of the word servitude. How does that relate itself to the basic right to property, if you can make that distinction?
Thank you for having me again in your studios, Danidu. I will commence my discussion with the law of property. The law of property, the center point of the law of property I see is the concept of ownership. And the concept of ownership has 3 important rights: the right to possession, the right to use and enjoyment of whatever you own, and the right of disposition. Now, these 3 rights essentially involve other rights coming under them. For example, if you take the right of possession, you will have the right to enjoy possession. And you will also have the right to recover possession where somebody has taken your possession away, or you have been put away from possession. And also, while you are possessing, you could also exclude others from possessing. So in a similar way, you will have sub-rights, if I may call them, under those major rights. And servitude happens to be also a right that a person who owns property, that a person who possesses property will also enjoy. So coming into the topic of servitudes as what is a servitude is rather easy for me to say it is a right, but it is a right that comes in the context of utilizing a property. Either you utilize it as a right of movement, or you would utilize that as an owner of that property also in certain situations, I would say. because you would want to identify servitudes in a very broader perspective. Because Danidu, the most easiest way to refer to a servitude is like calling it a right of way. Right. But right of way is not only a servitude. It is a servitude, but there are many other servitudes that you would see. So in the form of discussion, we will see more going into it. If you allow me now moving into the definition of a servitude.
Yeah.
A servitude, as I said, is a right. It is a right over a land which you would exercise independent of being owner or being in possession. Okay. You don't want either of those. You have only a right of servitude. So bottom line is, it is a right where you could exercise it over a land without being its owner or without being in possession of that piece of land. So it could be a right of way, it could be a right of passage of light and air, it could also be a right to draw water across adjoining land, etc., etc. So that would be my definition of what a servitude is. So as I said earlier, don't limit it to a right of way. It would include other rights. And moving further, you could also see classifications of servitudes. You could see how are these servitudes classified. One classification is predial servitudes. It is a servitude that is attached to the ownership of a land or a building, and it moves with the ownership. So if somebody sells that property, the predial servitude will move with the new owner. Right. So the next one is a personal servitude. This is a servitude given personally to a person or an individual, and it could be for a moment of time. Like, for example, the right of using a thing, the right of occupying a house, the right to consume immediate fruits or products, perhaps. Those would be personal servitudes. That is one way of defining servitudes or classifying servitudes. Another way to classify it is by saying it's an urban servitude, it's a rural servitude. Rural servitudes were the ones that were defined a long time ago because most of the area was rural. So you would have the right of way to livestock, right of way over a horseback, right of way for ordinary carriage, right of pasture for dairy and cattle, etc. Those would be identified as rural servitudes. So now moving on to urban servitudes, Danidu, we could see the right to build, the right to construct common walls, the right to have beams and supports being erected and being based on other people's walls, etc., or the neighbors' walls, the right of overhanging trees, the right of lateral support. These are all coming under urban servitudes. That is one way to classify it. Right. Another way is allowing positive servitudes and negative servitudes. Positive servitude would be a servitude where you allow the exercise of the right. Okay. A negative servitude is you would not do anything which would hinder the exercise of the right of servitude. Now, whatever the classification would be, you'll need a dominant tenement and a servient tenement. That is a fundamental concept when you're discussing servitudes. Dominant tenement is the owner of the land from whose land the right of servitude or the right of way, if I may say, will be exercised. The servient tenement will be the owner of the land over whose land this right of way or the servitude will be used. So it's fundamental, whatever the classification you would use, that you have to identify who is the dominant tenement and who is the servient tenement. That would be my brief classification of servitude.
So just to unpack that a little bit, so first of all, the classifications exist within common law, or do we have legislation that governs this?
That's a very good question, Danidu. Most of this area is Roman Dutch law in Sri Lanka. And I must say, if I may say, even 99% of the law is regulated by common law.
Okay.
I would think there are very few rules and regulations in local authorities where building permission is granted, where you'll have to adhere to those, but the majority is common law.
Right. So I think throughout the discussion, we'll have to talk a bit about the cases that are involved here.
I think so.
So now the distinctions between a dominant and servient tenement.
Yes.
Is one issue that I would, as you spoke about it, was, is there a confusion that lies there in the identification process of that, since you deal with cases here, or where does the key issues arise when it comes to identification of these classifications?
I think after doing a lot of these programs, you have become a master of asking questions on which are very relevant. I must say, there's a very relevant question you asked me, because Danidu, it's important to understand when you are filing action, who wants a right of way? Who wants a right of way over whose land? Yeah. So if you are going to identify the person who is going to assert the right of way, you will have to identify what is the land that you own. And the person who claims the right of way will be defined as the person who's the dominant tenement. So he will be the owner of a land to whose land this access route or the servitude is being sought for. And the next is, over whose land are you asking this right of way? Yeah. So the person who owns the land will be known as the servient tenement. In the case of Velupulle versus Subasinghe, 58 NLR page 385, at page 386, delivering judgment, Honorable Chief Justice Basnaika held, the kinds of servitude claimed in the instant case is real or predial servitude. Such a servitude cannot exist without a dominant tenement to which rights are owed and a servient tenement which owes them. A servitude cannot be granted by any other than the owner of a servient tenement, nor acquired by any other than by him who owns the adjacent tenement, who is the dominant tenement, I would think. So that basically summarizes. Permit me one more point, Danidu. In the case of David versus Jnanavati, 2002 Sri Lanka Law Reports, page 352 at page 366, also Honorable Justice Jayasuriya went on to say, in terms of section 41 of the Civil Procedure Code, it is important to identify the right of way and also who is the dominant tenement, who is the servient tenement. Once you identify them in terms of section 41 of the Civil Procedure Code, once a judgment is given, that judgment will be easy to be implemented by executing judgment, because you have identified the right of way precisely in terms of, the points of identification which will be needed once a decree is entered into to enforce it.
So just to develop on those aspects, I think it's quite clear now what a servitude is and the exact classifications that occur there. I just want to pick out this one thing that people generally discuss, and that's not the concept rather, but a squatter. That would I don't know if I'm taking this too early within our discussion.
Yes.
But how does because now the reason why I bring this up is now the ownership of a squatter is also something that is decided within our, that has been quite well explained within the law within our country. Is there any change that occurs to the classification of a dominant and servient tenement when considering a squatter?
Right.
If you can approach
it's a very good question. As far as the law is as at present, the person who is seeking a right of way should be the owner of the land adjacent to the roadway he is claiming, because otherwise there is no basis for him to claim a right of way over another person's land. Right. So you can't basically be a non-owner and be a dominant tenement. You know what I mean? So if you are the dominant tenement, your ownership to that property is important. So I would think a squatter would not be entitled to seek a right of way over another person's land. You have to show that you are the owner of the dominant tenement. It's very important at the very outset to say so. Actually, it's a very good point that you raise, because there is also a very important judgment, a very recent judgment that has been delivered by the Honorable Supreme Court, SC Appeal number 129/14, which was delivered actually, I believe, in this or in the year 2019. I'm sorry, in the year 2019, June 17th, by His Lordship Honorable Justice Amithirigala. His Lordship basically goes through this entire area of servitude, identifying who is a dominant tenement, who is a servient tenement. You should clearly lay that out in your plaint, and also moving from there and identifying what is a right of way, who has a soil right, who can prevent a person, etc., which we will be doing in your next segments. Yeah. But I just want to say, as far as these two are concerned, a person who's a squatter would not have a legal right to claim a servitude over another person's property.
Right. I think the next questions I have, so I think will really feed in well if we can go into the next segment and really iron it all out. We'll take a short break. We are in discussion with President's Counsel Seevali Amithirigala. You're watching Law, Land and Liberty. Stay with us.
And I'm a bio student. My question is about the creation of a servitude. How are servitudes created, and what are the key limitations that are present for their enforcement?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Seevali Amithirigala. Very important first segment that we just passed, and I think for a law student that's a very comprehensive breakdown of what the law of servitudes is. I recommend to anyone to just have a look at what we've just discussed. And now, sort of moving towards the creation of a servitude as an entire segment in itself. To approach this topic, I need to give you some time on this. Do we approach it with the case law, or do we look at it on the rights that are established, like on how the rights are established, basically something like necessity or things like that? How do we approach this?
Shall we approach it on the basis of creation of a servitude? Yeah. How are servitudes created? Yeah. There are three broad ways in which one can say servitudes can be created. Actually, it can be created by a grant. A grant can be a grant that is given by, let's say, the government of Sri Lanka declaring a particular roadway as a road. It could also be where a roadway is given by way of a deed. When somebody is selling their land with a right of way, they would transfer it to another person in terms of Section 2 of the Prevention of Fraud Ordinance. So one is how a right of way or a servitude can be granted by way of a deed or any other mode of granting a servitude. So one is grant. Second one that I would want to talk about is prescription. Prescription will be discussed in terms of Section 3 of the prescriptive ordinance in Sri Lanka, where, an adverse user over a period of time stipulated in the statute would acquire a right of way on the basis of prescriptive right. This is rather adverse, so there will be no permission obtained from the owner of the land over which the right of way is sought. It is adverse to his rights that over that period of time, which is 10 years, that they will be utilizing this road and thereby crystallizing it into a right of way. So here you would have a situation where there is no granting, there is no leave and license, there is adverse use over a period of time, and they crystallize that into a right of way or a servitude by way of prescriptive title. The next one that I want to talk about is necessity. Now, it's very important that you don't go and purchase a land which is landlocked. Yeah. And you have no right of way. But actually, if there is an area where you have no way of access to the main road, you could always seek a right of way of necessity. that would be very, very much limited to your immediate necessity of finding a right of way to the main road from which you can have access to other parts of the country where you're living in. So it's very important to understand your necessity very much. When we talk about this necessity or the right of servitude obtained through necessity, it is important to understand that are you willing to give at the end of the day some compensation or to the owner of the land over which you are asking this right of way over necessity. And it's also important to say that a right of necessity will not crystallize if you have an alternative road. If you have an alternative road, it could be difficult, it could be distance-wise longer to traverse to the main road. Those will not entitle you to obtain a right of way on the basis of necessity, because necessity has to be on the basis that it is the only road that I have to obtain access. Because you can't really impose your right of servitude, of necessity over another person's land unless, of course, it's really a necessity. So these are the main three ways you can obtain or create a servitude. It's very important that, to deal with compensation, I believe, I'm stressing on it for the second time, when it is a necessity that you're asking.
So I think the first two limbs of this are pretty straightforward. But necessity, I think, based on the number of questions that came to my mind as you were explaining it, clearly is where the entire issue lies, or a lot of case law might lie. Why did you stress on compensation, sir? Because now my question is, you mentioned in the initial part of your answer, it's important that we don't purchase, it is that we are cognizant of the fact that we are not purchasing a landlocked area, which makes sense.
Yes.
But at the same time, if we do, as in if that is a situation we're in, why is there a responsibility or a requirement for compensation to those individuals who we are claiming a right of way through?
Yes, I would think so, because this is not a right of way by grant or by prescription. You decide that you're going to live in that property and there is no roadway for you to move into the main road. And the access route will have to be obtained by way of necessity. It is not prescription, it is by way of necessity. So the adjacent land over which you are seeking a right of way is not going to be giving you a piece of land to traverse or to create a road just like that. So it's very important for you to understand in this mode of necessity that, of course, my experience is that when the case is going, there is sometimes instances where there is no methodology that has been used by the parties to calculate the compensation that has to be paid, etc., etc. But I think fundamentally, as a concept, it is important, Danidu, that to understand that just because you're living in a land where you complain you have no right of way, and for you to understand that the only right of way is over my land, that if you are going to obtain a road over my land, some compensation also have to be considered for me. Because it was not my fault that you did not have a right of way in the first place. Of course, if I was the person who was closing all your rights of way and so on, you will have a cause of action to get those things open. Then it wouldn't be on the basis of necessity. Necessity is a very clear species on its own, if I may say. So therefore, that is why I harped, secondly, also in two instances, that that compensation will have to be contemplated in that mode of acquisition of a servitude, because I think equity demands that a person be also compensated. You know what I mean, when his land is being used as a necessity. And what I want to say is this: you can't go and purchase a land knowing that it's landlocked and then start claiming also. That's also important. There is a decided authority in Sri Lanka with regard to that. If you go and buy a land which is completely landlocked, then you can't be asking for, saying, give me a right of way over your land, because you knew right throughout it was landlocked. when at the time of you purchasing. One of the most important ingredients of you sort of, deciding to purchase a land is to see whether you have a right of way.
Right. Yeah.
So I think it's very easy to drag this concept to absurdity. That is why limitations are there. Is there an alternative road? Okay. Just because it's very difficult for you to traverse it, that doesn't mean you're entitled to a road over my land. Secondly, is it the only road, as I said, only road, and establish it with evidence, and then compensation, I think, should be. This is something that I say. Courts have also considered it, and sometimes parties have lost sight of this, and modes of computation of that compensation is also important, but I think it's an important concept.
So I think, again, I believe this would be a straightforward answer, but just to get a clarification for Lem, and also an instance of, let's say, force majeure, or like an act of God.
Yes.
And then there is an isolation of land.
Yes.
And a situation is created after you purchase. In that instance, how does this entire thing work? Is it complicated?
It all depends on the facts and the circumstances of the case, Danidu. Okay. Because actually, it could be a man-made disaster. It could be God's act of God.
Yeah.
So it all depends on the facts and the circumstances of the case. What I would like to, in answering your question, is that if you have a desire to obtain a right of way, then you have to decide under what ground that you're going to obtain. Suppose if there's no way and you are going on the basis of necessity, then two important things would come. Is it the only roadway?
Okay.
Or are you entitled to a different road, and are you trying to find a convenient roadway? If that's the case, that's not permitted under necessity. If it is necessity, again, then compensation needs to be contemplated.
Right. So just to develop on all of that, I think the creation of a servitude aspect, the elements are quite clear.
Yes.
If under necessity you explain some of the limitations also, I think those are the two limitations.
Yes.
Are there any other limitations that we need to be aware of when it comes to the first two limbs, or can we move forward to maybe the case law that is relevant to this?
I think it's important to understand entirely this area is regulated by case law. Okay. So prescription as a mode of acquiring a servitude will be regulated with saying, you have to have a very clear path that you are claiming as a right of way, and then you have to use that adversely to the rights of the owner of the property, and then a period of time is required so that over that period of time you have used it adversely, then it crystallizes into a right of way on the basis of prescription. So it's pretty clear to identify that these are all areas which are regulated by case law with certain elements to be proved. For example, if it's a grant, in your deed, if you have a right of way, I think that's a very, very good piece of evidence to say you have a right of way.
Okay.
So it's very important when you are buying your property, number one, to see whether there is a right of way, and if that right of way presumably is in your deed.
Okay.
Yeah. Otherwise, of course, it's prescription or necessity.
Okay. So I want to give you some time on the case law elements that you can really explain to us on what is relevant here.
Yes.
Also, if we can, towards the end of this segment, talk a bit about how an ejection could occur, if that is relevant to this, so we can take it up within our third segment.
I think we can talk about the abandonment, or if I may say, talking about, for example, modes of losing a servitude.
Yes.
Exactly. How does a servitude comes to an end? Yeah. So that can have effect by, number one, abandonment. Okay. Abandoning a right of way or a servitude is something that is contemplated under the Roman Dutch law.
Just to get a clarification, there's abandonment would mean, what would that definitely mean? You will not be using the right of way for some time, or you are explicitly mentioning that this is not the servitude that you...
Yes. If you permit me to go through the judgment of Bambarawana Lianagamage Daya Elias Daya Abe Vikrama versus Nihal Dias and others, decided on the 7th of December 2012 by Her Ladyship Honorable Justice Shinani Tilakawadana, Justice of the Supreme Court. If I may quote from the judgment, it says, according to Roman Dutch law, non-user or abandonment of a right should be for a third of 100 years, which is 33 and 1/3 year, which means quarter of a century. So her ladyship was very clear in enunciating the principles of Roman Dutch law in saying, how does an abandonment or a non-user crystallize, and how can that be seen? For example, in this case, of course, there was no evidence of abandonment, but the concept of abandonment was discussed in that case. Next one would be a revocation. Next one also would be forfeiture, non-use, merger, renunciation. Destruction of the property could also be one, how a servitude can come to an end. And also, if you have been giving that right under leave and license, expiration of that period also could. And also, you could also have if the person who's granting you the right of way loses his title to that property, then also you would have a situation where the modes of servitudes will come to an end. So, as I said earlier, it all depends on the facts and the circumstances of the case. I just summarized the grounds how it has come into, but I think the most common way that you would see is perhaps the non-user. And also destruction of the subject matter, etc., that I have seen in my career in dealing with land law.
Sir, just one question that I want to repick on the compensation aspect, sir.
Yes.
Is there a possibility for the owner of a land over which the servitude is being exercised to maybe monetize that? In terms of a way of saying, okay, if this land is being used, this should be something that should be paid. Is that an aspect that compensation will be considered?
Of course it is. It is by all means an entitlement of the defendant against whom action will be filed for him to say, this is my land, and if you are asking, am I not entitled to compensation, asking the court to give an order of compensation, then of course he'll have to assess the compensation that he is seeking. Or if I may say, Danidu, majority of the cases that I've seen comes to a settlement. In the settlement, the party will say, why don't you pay me this much money for me to allow you the right of way over my land, perhaps on the basis of necessity. I've seen that on necessity a majority of times. But I think if there is no settlement and a decree is going to be entered, then you also can ask in your answer compensation. Because in the event that it is granted, compensation be granted to you. But assessment is important.
Right. Just to develop on that, sir, and please, if you have a case material that you want to give in, just feel free to interrupt me. Something that I just want to, if you can explain this to us also, if there's a breach of peace, I think this is an element that we need to talk about also. When a servitude has been given in a certain instance, and the exercise of that will result in something of that sort, how does the law or the common law really look into that aspect? What are the explanations that you can provide?
I'll bring the concept of ejecting and also the trespasser into it. All what I've discussed up until now was concerning actions in the district court relating to servitudes. But as you rightly say, servitudes also come in the form of a right again under Section 69 of the Primary Court Procedure Act. And whenever parties are having an altercation, let's say, disagreement, dispute, which is going to result in a breach of peace, then the police would report facts to the magistrate, and there will be what is called a 66 action before the primary court, which is the magistrate court. But of course, the relevant provision would be Section 69. Now, that's a very important provision, Danidu, because very recently, if I may say, recently in the sense about less than a decade, if I may say, coming closer to a decade in 2 years from now, in year 2013, it is important to say that His Lordship Honourable Justice Nawaz, not Honourable Justice Nawaz, let me correct myself, Honourable Justice Salam, in the Court of Appeal, clearly laid down how one could determine who is entitled to that right until the matter is sorted out in a civil court finally. Because in the magistrate court, you will not sort it out. You will give an order which will be for maintenance of law and order and to prevent a breach of peace. So what will happen is the court will give an order on the basis of saying who is the person who has been utilizing that right for the time being. So the quantum of proof to prove that you are the person who has been utilizing that right for the time being is not the same as in a district court. So you don't need to prove 10 years because His Lordship Honorable Justice Salam goes on to say you will have to prove 10 years in the magistrate court, also 10 years in the district court. So that is up to the district court to prove 10 years. But whoever who is utilizing that for the time being should be given the right to use that roadway until the matter is sorted out finally in the district court. So that's a very good question you asked. Let me cite the case also for the benefit of the viewers. The case is Paranagama versus Paranagama, CAPHC APN 117/2013, decided on the 7th of August 2014 by His Lordship Honorable Justice Salam when he was the President of the Court of Appeal.
Right. So I need to give you some more time, and I think we can talk a bit about the reformation aspect within our next segment.
Yes.
We'll take a very short break. You're watching Law, Land and Liberty. Stay with us as we go deeper into the subject of servitude.
And I'm a mechatronics graduate. My question is about reforms. What are the key areas of reforms required in the law of servitude?
Welcome back to Law, Land and Liberty. This is our final segment and we are in conversation with President's Counsel Seevali Amithirigala. So, two very important segments that we just passed, and I think the detail that you have gone into in each segment is very important to all of our viewers. This segment I want to really emphasize on reforms, but prior to that I also need to give you some time on any areas that we missed out on, and we can develop on that, particularly with regards to urban servitudes and rural servitudes that we couldn't really get into within our previous segments.
Yes.
Also, just to pose this question to you, so as you discuss, as we talk about this, you can really announce an answer also.
Yes.
When it comes to land-related matters from young ages to anyone who is old, they would always complain that the court process is slow and it takes too much time, and even the great work that a lot of lawyers are doing, even the Attorney General's Department is doing, is overshadowed by the fact that land cases might take long periods of time. In this instance, in the question of servitudes, is the situation the same? And if so, how should the Reformation really frame itself or position itself to address that?
My experience is that as far as servitudes are concerned, the time that is taken to resolve a dispute is not so much as a partition case. It is quite a lesser number of years that you would have. But of course, loss delays would anyway continue. I'm not going to talk about it in a very complacent manner, Danidu. But, disputes also don't stop.
Yeah.
Disputes also continue to grow. And when you look at a legal system and, the first thing they'll ask is, my God, the number of cases, aren't you trying to reduce? I think the judges, the lawyers, the legal community has been trying their level best. And you maintain a pace of, having a particular level of management because cases continue to come. Disputes continue. So the day it will be at the end, perhaps which would be perhaps an ideal state of affairs, which would not crystallize. But coming to your question, if I may be permitted to say that anybody who's interested in a servitude will have to be aware that there are two types of actions that a district court will have. These actions will be discussed in relation to the Roman Dutch law. The Roman Dutch law talks about two types. Act actio confessaria and actio negataria. Actio confessaria are actions to enforce a servitude. You need a servitude, you go and file an action, you are asking for a declaration that there be a right of way declared in my favor. Actio negataria, action to prevent a servitude. Or if you are the owner of a land, you go to court and say, please declare that there is no right of way over my land is free from a servitude. So these two types of actions are fundamental. Any legal practitioner who wants to step into a district court to have a case initiated on the basis of servitude, either getting one or negating one, will have to know these two actions. The actio negataria can only be brought or filed by an owner of the land against anybody claiming a servitude. So we haven't spoken about this servitude, right of way. Right of way means my right to proceed over a land which belongs to another person. So this right will be a merely right of way. While I also traverse that, the owner of the land also will be traversing that. But he will have, other than a right of way, a soil right to that particular portion of land on which you have a right of way. So only a person who has a soil right / owner will be able to bring an actio negataria to stop a person from utilizing their land on the basis of a right of way. It's very important to understand. The case of Melder versus Saparamadu, which was decided in 1996, reported in 2004, 3 Sri Lanka Law Reports, page 148. His Lordship Honourable Justice Asoka De Silva delivered judgment. In that it was said, actions relating to servitudes are categorized under Roman Dutch law as actio confessaria, actions to enforce servitudes, and actio negataria, actions to declare a property free from servitudes. Actio negataria can only be brought by an owner against one claiming a right to exercise a servitude over his property for the purpose of ascertaining whether a servitude existed. Also, it is to be noted that an action has been filed on the basis that the defendant appellant has no right to use the road. We are of the view that such an action can be filed only by a person who has soil rights and not by a person who himself enjoy only a servitude. So, a person who enjoys a right of way, Danidu, cannot stop another person who enjoys a right of way because both of them have rights of way. Only a person who has a soil right, utilizing actio negataria, can file an action to stop another person who is only using it as a right of way, preventing him from using, because you can only stop a person if you are the owner or having the soil right. Permit me to also say that subsequently in the case of Fernando versus Wickramasinghe, His Lordship Honourable Justice Veerasurya also held in this case, reported in 1998, 3 Sri Lanka Reports, page 37, where it was held, a person who has no soil right in respect of a road reservation could not maintain an action for declaration that the defendant was not entitled to a servitude of right of way over such road reservation. Predial servitudes can only pass with land, as I have defined earlier. Later on, a very important question came before the Supreme Court, where two parties, none of them had a soil right. Both of them had a right of way. One was trying to prevent the other from exercising the right of way. In the case SC Appeal number 57/2014, the case is Upul Vijaysurya Dialvis versus Rashdeen Kasim, decided on the 22nd of June 2017 by His Lordship Honourable Justice Cicero Diabru, Justice of the Supreme Court at the time. His Lordship went on to say that the law remains as the one that was discussed in Melder versus Saparamadu and also Fernando versus Vikramasinghe, and said that a person who does not have a soil right cannot prevent another person from exercising a right of way. In this case, both were people who had rights of way. They were not soil right owners. So if you were not a soil right owner, you could not prevent another person exercising a right of way. This is a very important case because in this case, perhaps the parties wanted to change the law and allow a person who has a right of way to prevent another person who has a right of way. But the court did not change the law. So law as at presently is going on the basis that only a person who has a soil right can prevent another person from exercising a right of way. This is the law as it is with regard to rights of way. And you need to identify what is a soil right as well. Soil right always accrues based on ownership.
Right. So I think we are running out of time, which is why I just want to get one small clarification,
yes.
sir. When it comes to right of way, if I'm not wrong in saying there is no exclusivity in right of way, one person can't claim a right of way for themselves. Unless,
of course, it's a private road.
Right. Okay.
If it's a private road coming into your property, then you have the sole right of way. Okay. But your question is right. Yeah. A right of way can't be exclusively if it's a common right of way. It can't be.
Can't be, right. So I think a lot more that we can discuss, but unfortunately time has come against us as usual. But I think a very informative discussion that we just had, something that we can revisit within our next programs as well. I hope you join us once again, sir.
I would, for sure, because it has always been a pleasure coming in. And also I hope today's program will be a benefit to the ones who are interested in servitudes. Yes. Thank you very much for having me, Danithu.
I'm certain it will be. Thank you so much for joining us, President's Counsel Seevali, Amithirigala. Thank you so much, sir, for joining us.
Thank you.
All right, sir. Now, respecting the rights of property of one another is essential in the smooth functioning of a society. Legal scholar and philosopher John Locke once said, "As much land as a man tills, plants, improves, cultivates, and can use the product of, so much is his property. He, by his labor, does as it were, includes it from the common." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/Other Derana English. I'm Danithu. Have a great night.